All right, we'll get this started. Hello, everyone. Gary, good to see you. And my name's Chris Berry, of course, and we do these every week at 1 o'clock, right when the tornado siren drill is going on, at least where I'm at. So I don't know if you hear that wherever you're watching or listening. But we like to do these each week, every Wednesday at 1 o'clock, and then they are recorded and they go up on our YouTube channel, which I invite you to subscribe to if you haven't already subscribed to our YouTube channel. You can watch past episodes. And what we do is there's really no form or format for these other than I'm just really answering questions that people have submitted the previous week or questions that are submitted live while we're having this conversation. It's really just a opportunity to provide value and education. I was having a conversation with clients today, and one of the things they said is there's so much information out there. They can't tell what's right, what's wrong, what should apply to them. So that's really, I think, one of my roles is to cut through all the BS and figure out what is the stuff that's true and what is the stuff that applies to a specific situation. Because there's a lot of generalized advice out there. And if you want to see, I guess, understand this is generalized advice too. And if you want to see how some of this applies to your situation, it might take a little more of a phone call. So understand that there is a lot of stuff out there. A lot of times we talk in generalities and there's a lot of exceptions to certain different rules. But my goal is to provide education, and when we're working with our clients, figuring out what their goals are, figuring out the best strategies, help them achieve the goal, and then pick the right tools. So with that, I always like to start with a positive focus, something positive that happened. For me, it's 2 weeks out of total hip replacement surgery. So I'm 41 years old. I didn't expect to have a hip replacement at this point, but I always joke around that your body is either going to rust out or wear out. I just didn't expect to start wearing my body out so soon. So yesterday I had my, Monday, I had my 2-week appointment, and I went from a walker to a cane. So I went from 6 legs down to 3 legs. So I'm improving. So I'm pretty happy about that. So that's my positive focus. Ed writes in, thinking warm. So that's good as well. So with that, we'll go ahead and get started. And again, I had some questions submitted ahead of time. But if something is unclear, feel free to put it into the chat, or feel free to put it in a question and answer, and I'll try to go ahead and address it as I'm going. So with that, let me go ahead and try to share my screen where I hit this button, hit this button, hit this button. All right. All right, so again, we do these every week. It's my pleasure to do these. Keep in mind, anything that we talk about, it's good to sit down and figure out how this might apply to your specific situation. So if you do want to see how this applies, I'm going to put the link in the chat, but feel free to book some time on my calendar at 15chris.com. And that should take you to a booking form to book some time on my calendar. So with that, we'll go ahead and get started. So the first question I have a traditional IRA, which includes after-tax basis of $16,000. I'm considering transferring the pre-tax amount to my 401k. Then can I do a tax-free Roth conversion of the remaining? The answer to this is yes. The key ingredient here is that it wasn't an IRA. So you can do after-tax contributions to Roth from traditional IRAs. I guess the one thing I would caution you about is typically we don't see people moving money to a 401k from an IRA. You certainly can, but I would just ask, what is the purpose of that? Maybe it's creditor protection, and we'll get into that shortly. But typically, with an IRA, one of the big advantages of an IRA is that you have a lot more freedom. freedom in terms of what you do with the accounts. For example, if you tried to do this strategy with a 401k, you wouldn't be able to do it. Second, you have a lot more freedom in terms of investment options with an IRA. You have a lot more freedom in terms of beneficiary designations with an IRA. So typically what we see people doing is they're moving money from 401ks to IRAs. We don't see very often, and I'd have to know why specifically we'd want to do it. We typically don't see people moving IRAs to 401ks. I'm not saying not to do it. I just would like to know what's the goal. Again, goal, strategy, and then tool. Maybe it makes sense depending on what your goals are, but typically once someone has moved that 401k to an IRA, they keep it as an IRA because you have a lot more freedom. Freedom in terms of investments, freedom in terms of beneficiary designations, freedom in terms of Roth conversions, just a lot more freedom. There are some exceptions that I can think of off the top of my head, but again, it would just be, what is your goal, and figure out the best strategy. But to answer your question, yes, you can do that because again, it's an IRA. If this money was already in a 401k, you wouldn't be able to do it. Number two, do IRAs and 401ks differ in terms of creditor protection? So this is to clarify something that came up previously. So both of these accounts, both IRAs and 401ks, are what's called qualified accounts, okay? So qualified accounts, one thing to keep in mind is that there is no Medicaid / long-term care protection for either one of these accounts. So if you were to need nursing home care, anything inside of your 401k, IRA, et cetera, would have to be spent down, whether it's in your name, whether it's in your spouse's name. Those are all countable assets, meaning they count towards that nursing home or Medicaid protection. But what they do offer is a form of creditor and bankruptcy protection, okay? And there is a difference. The difference is that 401ks fall under ERISA. So they fall under federal. IRAs fall under state law. And here's a little interesting distinction is IRAs are protected up to $1.3 million from creditors and bankruptcies. 401ks have unlimited protection. So if protection from like a bankruptcy is something that's super duper important to you, then maybe that is a reason why to keep money inside of a 401k. But keep in mind, either way, to get that type of protection, you would still have to go through a bankruptcy, which could be a big pain in the butt, right? Another easier option if liability or creditors are concerned would be to getting umbrella coverage. Like an umbrella policy through your property and casualty guy, typically you're going to get about $1 million worth of coverage for maybe $200 a year. So it's super cheap. So if, I guess, protection from creditors, not Medicaid or nursing home, is a big concern, I almost wouldn't want to rely on the bankruptcy protection. I'd rather just pay a couple extra $100 a year to build in that umbrella protection. Okay, but yes, you do have more asset protection inside of a 401k. So maybe if your big concern is asset protection, maybe that's a reason why to move that IRA into a 401k. But I guess there's different ways to do that. And first I'd look to something that wouldn't force you to go through a bankruptcy. I would look at maybe umbrella protections. And keep in mind, even though you do have this creditor protection, it does not apply to the IRS. Okay, nor does it protect against kind of spousal claims. So whether it's in a 401k or IRA, understand that it's not protected for long-term care purposes. It's not protected for any IRS issues. You don't want to mess with the IRS, and any type of spousal / divorce issues. Either way, whether it's 401k or IRA, it's not necessarily protected. Okay, so hopefully that's helpful in doing a deeper dive just on the asset protection of those qualified accounts. The big problem with qualified accounts, and we've been banging this drum since 2015 and especially recently, is that those are pre-tax accounts. That the biggest risk you have isn't creditor protection. I would say the biggest risk is tax risk, where if taxes go up, the value of those counts go down. Okay. Number 3, Ed Slott mentioned typically not to name the trust as a beneficiary of IRAs. Can you speak on why you recommend it and he doesn't? So again, this is getting to that generalized advice, and I had to grab this. This is actually hanging in my office. So let me just say that, like, I'm a big fan of Ed Slott. Like, that's me and Ed Slott. So I'm a big fan of him. In fact, we're Facebook friends, and so we've worked together. I've trained under him, so I'm a big fan of his. That said, if you were to kind of listen to any of his trainings or read any of his books, he's not a big fan of naming trusts as beneficiaries of IRAs and 401ks. And again, the reason for that is just he's having to give very, very general advice. So there's a couple of reasons why he says this. The first reason is that a lot of trusts, and again, not a lot of our trust, but a lot of trusts say everything goes outright to the kids or something at age 25 or 30 or 35. And so if your kids are over that age, what's the point of the trust, right? Versus a lot of our trusts build in the opportunity for a lifetime of asset protection. So by naming the trust as a beneficiary of the IRA, with our trusts, when we're talking about building in legacy protection, building in asset protection for the next generation, our trusts provide that protection versus a majority of trusts out there say outright to the kids at 25, 30, 35. So they don't give or offer the lifetime of asset protection. So the question is, why bother even having that basic type of trust in the first place? That comes into effect. 2, not all trusts include what we call stretch out provisions. Okay, all of our trusts typically do stretch out. So if the trust is not set up properly, all the taxes have to be paid within 5 years of naming the trust as a beneficiary. Unless the trust is set up properly, then we can stretch out the taxes to the maximum of 10 years under the Secure Act. Whether you name a beneficiary outright or you name a trust outright, you can only stretch those taxes up to 10 years. Now, there's a lot of trusts out there that don't qualify as designated beneficiaries, so they lose the stretch out. So if you have an unsophisticated trust that's set up, understand you might have to pay taxes sooner rather than later on those IRAs. Now, with our trusts, we build in provisions to allow that stretch. So when Ed Slott is writing general information to the general public, understand he's not expecting you to be an attorney to understand the difference or an advisor to understand whether your trust qualifies for the stretch or not. So he's giving general advice of, look, unless there's a reason not to, name the kids outright as beneficiaries. So naming the trust outright, the stretch, those are the big reasons why Ed Slott says to name the IRAs. But again, typically our trusts build in a lifetime of asset protection. So that's why you name the trust after the spouse typically. And then our trusts include the stretch out provisions, okay? In fact, we used to do a lot of standalone trusts just for retirement accounts. So, and trust me, I've had this conversation with many CPAs, advisors, attorneys, clients. Every time we have this conversation, almost always, depending on the trust we set up, we always name spouse first as a primary beneficiary, then trust. There's really no downside with naming one of our trusts the beneficiary of an IRA. If you didn't, you'd be missing out on this asset protection for the next generation, which is a big thing for a lot of my clients. They want to make sure that if they pass away, the money they leave to the next generation is protected from creditors. The money stays in the family versus going to an in-law, that type of thing. All right. Number 4. Let me see how we're doing. So a couple questions come in. I'll make sure to get to those. And let me see if there's anything in the chat that I've missed. Nothing there. Okay. All right. Number 4, is there any way around the 5-year look back period for Medicaid? So what we're talking about here is nursing home or Medicaid costs, which can run $8 to $12, $13, $14,000 per month, right? And especially with us living longer, long-term care costs are a big concern for a lot of people. And so that's where one of our strategies is to, if this is you, we set up an asset protection trust. We move assets into that trust, things like your home and other pieces of real estate, LLCs, money. And what that does is it starts a 5-year race where if we can make it 5 years from the time we fund this trust before we need nursing home or Medicaid, then everything inside of the trust is protected from that nursing home or Medicaid spend down. So now we could have everything protected inside of that trust once we've made it past that 5-year clock. So the question here is, what happens if we need long-term care at some point during this period? Well, one option is we just private pay to get to the 5-year mark, okay? In fact, I'm working with some clients right now, complicated situation. They have lots of pieces of real estate, lots of lots. He's diagnosed, we have a husband and wife, he's diagnosed with Parkinson, unsure if we'll make it the full 5 years. But we're still setting up the Castle Trust, moving these properties into the trust, because once we make it 5 years, if we do, 100% of everything in the trust is protected. Plus it protects the surviving spouse as well if husband were to pass away. But let's say we don't make it 5 years. One option is we just private pay. So we use other funds or take money out of the trust to get to that 5-year mark. Okay, so it's not just 5 years from the time we need nursing home care, it's 5 years from the time we submit that Medicaid application. So maybe if we get to year 4, we private pay to get to that 5th year, and then now everything inside of the trust is protected. The other option is we can always back out of the trust and we do what we call Medicaid crisis planning. And this is available even if you have someone in a nursing home right now, okay? So if you have a loved one in a nursing home right now, they've done no pre-planning, and let's say they have $300,000, one option is you just spend down that money to get to $2,000, which is the asset limit for Medicaid. The other option is we could do a Medicaid crisis plan where, depending on the situation, we might be able to protect half of those assets. So roughly $150,000. So if you had a loved one in a nursing home right now paying $10,000 a month, there's things we can do at the last minute, super complicated. And we call this Medicaid crisis planning, but we can protect a portion of that money. So ideally, when we set this up, we set up the Castle Trust, we make it 5 years, 100% of what we put into the trust is protected. But if we don't make it 5 years, or we have a stroke right away, or we're in a nursing home now, we have last minute, almost like Hail Mary type strategies to protect at least half of the assets typically, okay? So it's not all or nothing. We do have strategies even if we don't make it 5 years. All right, number 5, and then I'll get into some of these other questions that have come in. My house is in the trust. Can you explain the difference or reason behind a ladybird deed? Yeah, so really we have 2 approaches with regards to real estate. So how do you handle real estate? So there's 2 ways that we handle real estate, and it's going to just depend on what type of trust do we have. Okay, so if we have let's call it a revocable living trust. So this is a trust that avoids probate, distributes assets to the kids, maybe protects the kids. And we have real estate. The way that we fund that real estate is with what's called a ladybird deed, okay? And I'll talk more about that in a second. So the home is in your name while you're alive. You can refinance it, you can do whatever you want. But if you pass away, the ladybird deed says it flows into the trust and goes to the beneficiaries. Now, the other option is you have what we call a Castle Trust, which is an asset protection trust, which is different than the revocable trust. In this situation, we would deed that property directly into the trust, okay? So now the trust is the owner, very different than the ladybird deed. So understand, when someone passes away, there's 4 ways assets transfer. We call this estate administration. And first would be joint ownership. So husband and wife, one of you passes away, goes to the joint person. Never recommend naming your kids joint on your real estate. Don't do that. There's a whole slew of reasons why not to do that. Second would be beneficiary designations. So 401k IRA, you named a beneficiary. Third would be through a trust. You follow the terms of the trust. But if an asset doesn't pass through one of these first three, then it ends up going to probate. And that's, of course, what we want to try to avoid. So really what the ladybird deed is number two. Is a ladybird deed is basically just a beneficiary designation for your home. The home is in your name while you're alive. You can refinance it, you can sell it, do whatever you want. But if you pass away and you still have that house, it flows into the trust and follows the distribution terms of the trust. The advantage of that, so what does this do? It avoids probate. Okay. All right. Now the other option is, let's say you have an asset protection trust, a castle trust. We would deed it directly to the trust because A, it avoids probate, and then B, you get the asset protection of it that the asset protection trust would offer you. Okay. So you could sell the property, the proceeds of that would be protected. So really, we're either doing a ladybird deed or we're doing a deed directly to the trust with an asset protection trust. So a couple of questions regarding this. 2019, built a new home. And our names that had you update our trust include the trust via ladybird deed. Did you file that with the city or do we need to do that? So with a ladybird deed, either one of these deeds, whether we do the ladybird deed or we deed it directly to the trust, we always file it. So it's always filed when we sign it. We send it to the property, or we send the property transfer affidavit to the county, so the tax assessor knows and it doesn't uncap any of your property taxes or anything like that. So nothing you need to worry about. Ladybird deed would be deeded directly, held in your name. We would file the deed with the county, and then upon death, file a death certificate and transfers it to the trust or to the kids. Yep. So you are welcome. A couple of questions here that have come in. So that's all the questions that came in ahead of time. Here's a question. Advice regarding investing in dividend-paying stocks. I'm going to have to figure out what you're trying to do. My only concern with dividends are they're not a sure thing. I'm not saying that's the only way to create income, but that is a way to create income. The only concern would be whether those dividends would continue. Also, that can create some taxable issues. So one of the things we do focus on is income planning. And a lot of times I'm trying to create tax-free income sources. So if we're relying on dividends, that's going to be something that potentially could cause us tax issues for the rest of our life. So that is one approach. I'm not saying it's a magic wand. I'm not saying it's wrong. It's all about figuring out what are your goals. So if your goal is to create income, is looking at dividend paying stocks one strategy? Sure. Can we help you with that? Yeah. But we'd want to look at all the other strategies to pick the best strategy, and then we could pick the best tools. Okay, what is a portfolio that'll be generating the dividends you want if that's the strategy you want? So I'm not pro or negative against that. It's just a different, it's another strategy that's available for income planning. Another question. My sister was married over 20 years ago, has been divorced for over 10 years. Can she collect off his Social Security as a former spouse? He is remarried, but she has not. Does this affect her collecting on his account? Social Security, the first key is that they have to have been married for 10 years. As long as they were married for over, married for over 20 years. So you said that. All right. And she cannot be remarried. So if we have, so we're talking about Social Security here, and let's say we have husband and wife, they get divorced, husband gets new wife, then the ex-spouse, she can make a claim on husband's Social Security. The fact that he remarried or anything has no effect on her Social Security. So she should be able to make a claim on his Social Security. And what I would do is I would just contact Social Security directly, and they can calculate the amount that she'd be entitled to. What is the difference between a SEP and a 401k? 401k is typically going to be an employer-sponsored plan. They fall under different tax codes. A SEP, and I'll have to double check this, this is going to fall more into the IRA side of things if you're concerned about asset protection. So it's going to differ from a 401k with regards to the asset protection. But both of them typically are going to be pre-tax accounts. Another question, can you refinance a home once it's deeded to the Castle Trust? The answer is yes, you can. In fact, the language in the Castle Trust specifically allows you to do that. The only thing that you have to do, and we've partnered with some companies that can do this, is you need to make sure that the mortgage company will refinance inside of the trust. Because every mortgage company is its own private entity and they can choose kind of what they want to deal with or not. Some of them just don't want the hassle of dealing with a trust, but we do have firms that will help you refinance inside of a trust. All right. Okay, so any other questions? Please go ahead and put them in now. Otherwise, looks like still a beautiful yet cloudy day. Can get out and enjoy some weather. So if you do have any more questions, all right. Here's the goal is to be able to make backdoor Roth contributions without needing to pay any income tax on those contributions, conversions, since there would be no other IRA, thereby avoiding pro rata calculation of taxes due on the backdoor Roth contributions. That'll be a more detailed answer that I'd have to get into, Laura Lee. My feeling is that you could do that inside of an IRA. You just have to split the accounts. But yeah, that's kind of a detailed, very detailed strategy. So probably more than we want to get into on this. Anything else? Any other questions coming in that I can answer on the fly? Victoria writes in, glad to have you back. Thank you so much. It's good to be back in the saddle. So with that, thank you, everyone. If you do have additional questions, feel free to submit those for next week. If you want to see how any of this applies to your information, feel free, or your situation, feel free to shoot us an email or feel free to book some time on the calendar. Nikhil, thank you. Thank you so much. All right, well, take care. Make it a great week, and I'll talk to you next week.